Committee will come to order. We do have a quorum and we're ready for business. We're only short the transportation chairman. He's stuck in neutral on the fourth floor. Committee, we have the minutes from March 3rd, 6th, 8th, 9th, 13th, and 14th. Our secretary's been extremely busy. Representative Armstrong.
Mr. Chairman, having read the minutes of March 3rd, 6th, 8th, 9th, 13th, and 14th, I move that they be approved.
You've heard the motion. Is there discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion is carried and the minutes are approved. Committee will now have under consideration RS 25434. Mr. Stevenson. Our
Good morning,
favorite
Mr.
bill of the
Chairman.
year.
Or should I say top of the morning, Mr. Chairman?
Oh, whatever.
Mr. Chairman, I bring this RS to you on behalf of the Legislative Services Office. Apparently, you've got them working so hard they couldn't send anybody down here, so they called me. RS 25434 is this is the bill that's known as the drop-dead bill. This piece of legislation, as you know, Mr. Chairman, the Section 675292 of the Administrative Procedure Act states that all previously extended administrative rules automatically expire on July 1st unless they're statutorily extended. This is a legislation that continues in full force and effect those rules that were previously approved. It also continues those rules that were affirmatively approved or extended by concurrent resolution that were approved this session. Section 3 of the bill excludes those rules that were rejected by concurrent resolution and declares them null, void, and of no force and effect. Excuse me. It's a simple bill, Mr. Chairman. It's very important, and I say that not just because it allows me to continue to work after July 1st, but you know the ramifications of this. With that, I would stand for any questions and ask that you approve this.
You know what our temptation is, don't you?
Yes, Mr. Chairman, I absolutely do know what your temptation is.
Are there
Please,
questions?
please don't fall to that temptation.
Well, we'll not submit. How's that sound? Hearing no questions, the RS is properly before the committee. Representative Harris.
Chairman, I move that we introduce RS 25434.
You've heard the motion. Is there discussion?
You prefer it going anywhere other than first? You want to go to the second reading there, Chairman?
It would be.
Let's do that. Let's move it to the second
We
reading.
probably don't need to have a hearing on it.
A lengthy hearing.
A lengthy hearing?
Let's get to 2 hours. Let's go to the second reading on that, Chairman, is the motion.
I'd rather not.
So second reading, please.
If there's no discussion, the motion is to introduce RS 25434 and send to the second reading calendar. All in favor say aye. Aye. Opposed, no. Motion is carried and it will be done. Representative Harris, do you want to do the honors?
I see Scott Bedke's name on here, but I'd be happy to.
Well, I think he may be in the chair that day. So. Committee will now have under consideration RS 25520. Representative Crane.
Thank you, Mr. Chairman, members of the committee. My name is Brent Crane, a state representative from District 13 in Nampa. Today you have before you RS 25520. I know this is probably not the gold standard of RSs this year, but I can assure you, Mr. Chairman and members of the committee, it is a great RS. The genesis for the RS has to do with a contested election on Castellamines v. Nye that took place in the Senate this year. And subsequent to that, the Senate found that their rules were lacking and providing direction for the challenge of that election. As you're well aware, if there's a contested election in the House of Representatives, we as the legislative body sit in judgment of that election. And so subsequent to that, the Speaker put me together with Senator Davis and Senator Sidaway and LSO staff to draft rules for how that process would operate in the House of Representatives. They have an identical mirrored version of this in the Senate. You will also see two other pieces of legislation. You will see a joint rule, because if there's a contested election for a constitutional officer, we would have the House and the Senate come together and sit in judgment of that election. So we'll have a joint rule. And then also you're going to see legislation coming forward rewriting how that process operates. The Senate found that there were several things that were lacking in providing direction for them. So this is intended to provide direction. With that, I'd stand for questions.
Are there questions? Hearing none.
Thank you.
Remind the committee that this is a leadership bill.
No.
Representative Monks.
Thank you, Mr. Chairman. Maybe I could ask a question of Representative Crane there.
Gentleman yield.
Certainly.
Representative Crane, were you anticipating having a hearing on this, or is this something that we just wanted to move it forward?
Mr. Chairman and Representative Monks, the Speaker asked me to have this introduced by no later than today, and would like to have a hearing if possible on the bill this year and move the bill this year. You're also going to see, as I referenced in my testimony, you're going to see two other pieces of legislation this year coming from the Senate. We're hoping to hold this up and have a hearing in one day on all three pieces of legislation so you can see how the puzzle piece fits together.
Mr. Chairman, for a motion.
Representative Monks.
I move to introduce RS 25520.
You heard the motion. Is there discussion on the motion? Just might make the committee aware that this probably won't come to this committee. These rule changes usually go through June rules, so it'll probably go to a different committee. You've heard the motion, and the motion is to introduce RS 25520. All in favor, say aye. Aye. Opposed, no. Motion is carried. And the bill is introduced. Yeah, you can stay here for that matter. Committee will now have under consideration House Bill 184 as amended in the Senate. The purpose of this is to recommend whether or not we would like the House to concur with the amendment. So, Representative Monks.
Thank you, Chairman. So I tried to figure out what this amendment actually had done, and it looks like it's basically just some wordsmithing to have a little bit clarification on the bill that we had passed here out of committee and that had already passed out of the floor as well. And if you look at the amendments there, they look pretty innocuous. That just some clarification as far as the duties and responsibilities of the treasurer, and with that, I would recommend that we concur with the amendments.
Are there questions? Hearing none, a motion is in order. Representative Monks.
Chairman, I move that we concur with the amendments on House Bill 184 as amended in the Senate.
You've heard the motion. Is there discussion? Hearing none, the motion is to recommend to the full House we concur in the amendments, the Senate amendments to House Bill 184. All in favor, say aye. Aye. Opposed, no. Motion has carried. Committee will now have under consideration Senate Joint Resolution 103. Senator Lakey.
Mr. Chairman, members of the committee, for the record, Todd Lakey, Senator from District 12. Mr. Chairman, committee members, good morning. It's my, I guess, privilege and honor to be in front of you this morning and present SJR103. Mr. Chairman, I also have Professor Paul Cassell, who will be presenting among other folks. He will probably be following me. And I may have to be over on the other side of the rotunda, depending on how long we go, and he can provide any wrap-up if we need to, Mr. Chairman. Representatives, this resolution is about giving crime victims in Idaho the opportunity to have an effective voice in the criminal justice system and make sure that their rights are not overlooked. If this passes, ultimately, it's placed on the ballot in 2018, and the people of the state of Idaho decide whether this is an appropriate amendment to our Constitution regarding victims' rights. Professor Cassell can give you more history, but our language that we have now comes from back in 1994, and at that time, Idaho was considered a leader in victims' rights. And I think it's important, after 22 years, that Idaho remain a leader in victims' rights in the country. This builds upon the foundation that we have right now, which is notice, opportunity to be present, and opportunity to be heard. Most people, all of us, go about our daily activities, pursuing life, liberty, and their pursuit of happiness. We make decisions on where we go to school, how we do business, what we do every day. And thankfully, most of us don't have to be involved in the criminal justice system. But a victim is one whose right to life, liberty, and pursuit of happiness has been taken or harmed, sometimes irreparably, by the actions of another. They don't choose to get involved in the criminal justice system. They're brought into it essentially against their free will and choice by the choice of another. And that's part of the reason that it's so important from my perspective that their rights be protected at the constitutional level. Representatives, we have a system of laws in this country. It's not perfect, but I think it's the best system in the world. Part of that system is we place trust in the system, that the laws will hold people accountable so victims don't have to take justice into their own hands. It's very important that we make sure that the one that's victimized has an effective voice in exchange for that trust that we place in the justice process. A criminal defendant's rights are well established and well protected in the system that we have now. These victims' rights do not supersede those rights of a criminal defendant. Representative Luker and I worked on the reform to the public defense system. We were members of that committee and helped shepherd that through. That was the right thing to do. Representatives recognizing and protecting victims' rights is the right thing to do. And personally, I feel even a stronger sense of duty in that regard than the other work that we did. My personal experience is not great as a victim of criminal activity. We've had some minor things stolen. You feel like your property and your peace and tranquility have been violated, but there are certainly others in this legislature that have experienced much more severe effects as a victim of criminal activity. Most of my experience comes as a former prosecutor, watching and helping other people deal with the criminal justice system as victims. The deep and personal impacts a victim and a family member suffers necessitates that these rights be protected at the constitutional level. The language that we have, I'll go through that a little bit, but this results from many hours of collaboration with victims' rights advocates, with legal scholars and attorneys, including Representative Malik, with prosecutors, and with representatives from the courts. We have strong support from our law enforcement community, the Sheriff's Association, the Fraternal Order of Police, and the Idaho Prosecuting Attorneys Association. And I want to give special thanks to those folks. They're the ones that deal with victims on a frontline basis. And especially the prosecutors, when they get into the system, I guess they're the closest thing that we have to somebody that's looking out for the rights of victims. And they're very committed to this legislation and that concept. It builds on some concepts that we've seen nationally, but this is Idaho language. It's developed by people that are involved in the process and that are here in Idaho. So, representatives, I can go over the language just briefly and hit some of the high points. It provides for reasonable and timely prior notification. Unfortunately, I've seen as a prosecutor where victims, the notice may have been missed. Usually it's a standard notice that you provide. A letter that's mailed to the victim as to when the court proceedings occur. I've seen that occasionally missed, and a victim is attempted to be contacted by phone within hours prior to the court proceeding. This provides that it needs to be reasonable and timely. It also provides for reasonable and timely notice of escape or absconsion from probation or parole. It provides the right to confer with the prosecutor. Currently, it's communicate. Confer is a little stronger word. It means some interaction. It doesn't mean direct the prosecutor, but it means provide input and discuss, not just communicate. It also provides for full and timely restitution for economic loss. And Representatives, that term was included. There was some concern that this might devolve into the tort world. Economic loss ties it to those economic impacts that a victim suffers, and that's already defined in code in 1953-04, 1A. It also, a victim can be a person or an entity. That's also already included in code. If you're a company and you have something stolen or embezzled, you're a victim. But it provides and maintains the ability of the courts to prioritize among victims. You may have the person directly injured be reimbursed through restitution, perhaps prior to the insurance company that had to cover a loss. But that's in the discretion of the court. It provides for reasonable protection from the accused and those acting on behalf of the accused. Representatives, that's in the context of the criminal justice proceedings. We're not talking about having a court order a police officer to go stand at somebody's door. This is in the context of the proceedings, so they don't have to talk with the defendant. They shouldn't be in the same small waiting room with the defendant or their family as they go into court. It also provides reasonable and timely opportunity to review the pre-sentence report, which is prepared in both criminal and adult proceedings. And then again, it clarifies that this includes the criminal justice proceedings and defines that. It adds additional proceedings including post-conviction relief, parole discharge, change of probation status, commutation, pardon, and post-arrest and post-conviction release. It excludes ex parte proceedings like grand jury proceedings. Those are simply the prosecutor and the grand jury making a decision whether a charge should proceed forward. So there are some exclusions for that. One of the most important things, it specifies that the victim has a choice for themselves in the process, whether to speak for themselves or designate a family member or other representative or have their attorney or the prosecutor speak for them and assert their right to be heard. Representatives, that's one of the most important things, I think. The court process is very intimidating. Most people aren't comfortable in a courtroom, and especially when you have an individual that's had their life altered and they're in the close proximity with the one that victimized them or altered their life. I can remember as a prosecutor, sometimes we would sit at the same tables in the courtroom for different jurisdictions. And I was there on behalf of my jurisdiction, but I didn't know. I had a friend come into the courtroom that was a victim in another case, and she had to come up to the table to address the court. Her daughter had been hit by a reckless driver, and she really struggled. She was nervous, she was shaking. I ended up holding her hand as she talked about how her daughter had to go through weeks in the hospital and months of physical therapy, and the fact that she would never be able to walk the same again in her life. And it was extremely difficult for her to be able to verbalize that. That's why victims should have a choice in how they have their voice heard in the justice process. It also provides for a definition of victim, and that's a foundation. Representatives, it sets a floor. We have the ability as a legislature to build on that floor. It also emphasizes that these victims' rights do not supersede the defendant's constitutional rights. They don't have an independent right to participate in trial or object to those proceedings. But it strengthens the foundational rights that we have in place now. It's all discretionary. The victim chooses whether to exercise those rights. There's no mandate in outcomes or participation. The discretion remains with the court, the parole board, or the governor. And it gives the victim simply the opportunity to be heard and those decision-making bodies to make a decision with that input. Mr. Chairman and Representatives, I would ask for your support in this effort to give crime victims an effective voice in the criminal justice system that they wish they never had to be a part of.
Are there questions?
Let's stand for questions, Mr. Chairman. Thank you.
Representative Barbieri.
Thank you, Mr. Chairman. Senator, you
made reference to tort, and on page 2, line 11, when you talk about the victim being able to seek enforcement of the rights enumerated, how do you see that playing out?
Mr. Chairman and Representative Barbieri, again, in the context of tort, it's simply related to economic loss. So in the restitution context, that would be where that applies. The victim would perhaps have the opportunity to challenge the sufficiency of the restitution order. We needed to be reimbursed for this or this as well, and ask the court to reconsider their restitution order. Those are the kind of rights that they would potentially be asserting. Also, the right, if a notice was missed and they weren't given opportunity to go to the sentencing hearing, assuming the defendant's constitutional rights are not violated as far as speedy trial or due process, they could ask the court to reschedule that proceeding because of lack of notice.
Representative Barbieri?
Thank you, Mr. Chairman. So, setting aside the tort aspect of it, then, you see the enforcement, seeking enforcement of the rights as that enforcement being within the context of the criminal action against the defendant or the accused.
Mr. Chairman and Representative Barbieri, that's correct. It's only within the context of the criminal justice proceedings. That preliminary language that we have on page 1, line 11 and 12, ties all of the language to the criminal justice proceedings alone.
Representative Barbieri?
Thank you, Mr. Chairman. So I just want to focus then on the terminology you're using here on lines 20, 36, and then again later on in the proposed language for the election itself on reasonable. How do you see the use of the term reasonable in these contexts rather than, as I may read it here on line 19, in addition, a crime victim shall receive timely notification of escape? How does the modification or adding the term reasonable assist in the rights of the victim?
Mr. Chairman
Senator?
and Representative Barbieri, again, ultimately, reasonableness is a standard that the courts are used to dealing with. It's a court's decision. The previous language was simply prior. So the example that I gave where a victim gets a phone call within an hour of a proceeding, say, for example, to reduce bail or bond. The court and the prosecutor both typically discuss whether victim notice has been provided. The court could inquire as to when the notice was provided. If it was given an hour before, the court may make that determination. That's not sufficient notice for the victim to change their schedule. We need to continue this hearing to a particular date. But all that is subject to the speedy trial and other due process rights of the defendant. And the right of the victim, essentially that's an opportunity for them to be prepared, perhaps adjust their schedule. The court and the prosecutor don't talk to the victim and try to schedule around the victim's schedule. It's a matter of them scheduling the time and making the victim aware. So the victim has to adjust their schedule to be there. So it's an opportunity for them to try to be prepared and adjust their schedule.
Representative
One
Barbieri?
more, Mr. Chairman. So in that context then, on line 36, we're now saying reasonable protection. That modification of the word protection, how do you see that playing out as far as not just absolute protection, but it's got to be reasonable protection?
Mr. Chairman and Representative Barbieri, again, that would be up to the court's discretion to determine the reasonableness, but it could be an example, say you have a very small courthouse, and you typically don't want the victim to have to be in the same small waiting area as the defendant and their family members, and have to potentially, face questions or those kind of things. But if the courthouse is small and you don't have another area, an office or something where they could go wait in, it's not reasonable to build a new courthouse and be able to accommodate them. So you do your best.
Representative Luker?
Thank you, Mr. Chairman. Senator Lakey, you mentioned the public defense reform that we worked on, and of course that all derives from Sixth Amendment protections. And we currently have considerable victim rights that were enacted in 1994 in our Constitution. And it seems, at least in the public defense sector, what we did is put into statute protections for the public defense. And what it seems like we're doing here is putting a lot of detail into a constitutional form that precludes the legislature from making tweaks and things in the future that would be available under statute. Can you tell us why the vehicle you're using here today is a constitutional amendment?
Mr. Chairman and Representative Luker, as I mentioned, this was done in '94, and Professor Cassell can kind of talk about the history and the trends that we've seen. But for me, it comes down to the fact that the impacts that a victim suffers against their will necessitate a constitutional level of protection. This provides essentially a floor. It adds those additional proceedings that are not covered now as being constitutionally protected proceedings for them to have their voice heard. And then the definition of victim itself, as I mentioned, is a floor. It provides for the legislature to expand that definition. Existing code could still be applicable as we define a victim, assuming it's not contrary to that. But that's a fairly tight definition of victim. It provides the legislature the opportunity to build on that.
Thank you.
Representative Luker.
Yeah, follow up, Mr. Chairman. Senator Lakey, there are a lot of other areas in here that deal with definitions, though, including criminal proceedings and what's included there. And what does it mean to be present? So I guess my concern is, once this is in the Constitution, we as a legislature have virtually no ability to come back and change what might be a problem down the road. Can you comment on that?
Mr. Chairman and Representative Luker, that right to be present is already there. That's one of the foundational principles, the notice, the opportunity to be present, and the opportunity to be heard. This simply adds to the existing list. Right now, the Constitution provides a shorter list of things that the victim has the right to have those foundational principles applied. So there's already a definition. This adds to those specific proceedings that they have a right to be a participant at if they choose to. If the legislature chooses to add to those proceedings, they can. But this, again, is a floor. These are the specific proceedings that are constitutionally protected. So it's an addition to an existing list.
Representative Luker.
Thank you. Follow up, Mr. Chairman. Senator Lakey, well, speaking of the right to be present, on line 22, we're striking at all criminal justice proceedings, which is defined elsewhere in the bill now. But what does it mean simply to be present? Does that mean that the victim has the right to go into a in-chambers meeting with counsel and the judge during a trial?
Mr. Chairman and Representative Luker, I guess first is that this doesn't change the right to be present. That right is there. This adds to that specific list, and then it excludes ex parte proceedings where it may be just one party or the other. But that has not been applied to mean that right to be present that exists now has not been applied to mean the victim goes back into chambers where the judge is talking with the prosecutor or defendant about an evidentiary ruling or whatever they may be talking about. It's the right to be present in the courtroom, observe the proceedings as they're happening, and that helps them to determine what or how they may want to participate or what they may want to say in the proceedings as they go forward.
Follow up, Mr. Chairman.
Representative Luker.
Thank you, Mr. Chairman. Senator Lakey, so why are we striking at all criminal justice proceedings? It seems to me that there's an intent to broaden that leaves it ambiguous as to what to be present really means.
Mr. Chairman and Representative Luker, the previous, or I should say the existing constitutional provisions provide different lists in different places. What this does is consolidate that list in one location. on page 2, line 1, and then provides that precursor at the top that all of these rights, which are, rather than include a list in each specific one, are reduced to the basic right, and then the criminal justice proceedings are defined more specifically on page 2, which adds those additional items that I talked about. So it's really a consolidation and a clarification, and then putting criminal justice proceedings in one section by itself.
Okay, and one more.
Representative Luker.
Thank you, Mr. Chairman. Senator Lakey, have we had, given our current protections in our Idaho Constitution, any Idaho judicial rulings that were adverse to victims' rights?
Senator?
Mr. Chairman and Representative Luker, I think you'll have, I guess, an opportunity to hear from different victims and their experiences in the process. You have victims that have good experiences, and you have victims that don't have good experiences. I'm not aware of a case, maybe perhaps Professor Cassell is, where there's been a challenge to the existing victims' rights that we have now. I think in Idaho, we do a fairly good job of being aware of victims' rights. But again, you'll hear from folks that have not had good experiences. What this does, again, is provide additional opportunities for that voice to be heard. So Representative Luker, under the existing framework, I don't know if anybody's challenged that existing framework and been successful.
Further questions? Representative Scott.
Thank you, Mr. Chairman. Senator Lakey, I have several questions. Most of them have to do with language. My first question is on line 10. Why did you remove the as defined by statute for a crime victim?
Senator?
Mr. Chairman and Representative Scott, it comes back to that foundational principle that the rights of and the impacts on victims are so deep and abiding that they need to be protected in the Constitution. So we took that language out and we provided the definition of victim that you find on page 2, line 14. And that's the floor that I referred to Representative Scott. There's your basic definition of victim. And then that provides that the legislature, this body and the body across the rotunda, can add to that or augment that.
Follow up, please.
Representative Scott.
Thank you, Mr. Chairman. Senator Lakey. So that does lead me into my next question then. So the way I read this, we're not only to including a crime victim as a person, but also an entity. And what I'm envisioning is a shoplifter at Walmart. Walmart would be the victim in this case of a shoplifter. Would they fall under entity as a victim?
Senator?
Mr. Chairman and Representative Scott, an entity certainly can be a victim. As you mentioned, Walmart. They're a company. If they've had merchandise stolen from them by an individual or an employee, from a restitution perspective, they are a victim. So they're entitled to have that loss reimbursed. If it's another company and an employee embezzles from them, the same thing. But that's not a new concept. Representative Scott, if you look in 1953-04, the definition of victim says the directly injured victim, which means a person or entity. So entity is already included in our existing code.
Follow up, please.
Representative Scott.
Thank you, Mr. Chairman. Senator Lakey, so does that mean that let's just use Walmart for the example here, that we are going to be providing companies now all these, all these rights that you're giving on the change in probation? We're going to be notifying all these companies for these small crimes, the acceptance if the person plead guilty or not. It just seems like a lot of notification, and I'm trying to understand that better.
Senator Lakey.
Mr. Chairman and Representative Scott, thank you for the question. The Walmart example is a good one, I guess, for context or description of when a company may be a victim. But we're not talking about the minor crimes. If you look at the definition of victim in 14, it includes any person or entity directly and proximately harmed by the commission of a felony. So a theft would have to be a higher level of crime, not a shoplifting, or a misdemeanor involving physical injury, threatened physical injury, or sexual offense. So it's the crimes of violence. We could add to that if we felt like misdemeanor thefts were appropriate as included as a victim. But primarily when we're talking about safety and those kind of things, you're talking about a victim of a violent crime. But if it's a felony, the company would have the opportunity, say it's a small business owner that was embezzled, he would have an opportunity, or she would have an opportunity to come to the court and say, because of this loss, I've had to lay off employees, my company is going under, and the court would be able to consider that.
One last question.
Representative Scott?
Thank you, Mr. Chairman. Senator Lakey, I'm just, the language, reasonable and timely notification, full and timely restitution, reasonable and timely opportunity. I'm just wondering, I look at the Constitution of Idaho, and it's very simple. And this is a ton of language we would be adding to it, where there's, the amount of room this is going to take up on a page, we have several different articles. And so I'm wondering, could this be shortened to just notification, restitution, opportunity, and written in a broader way, and then the rest of this be worked out in the code itself? Could this work to just be brought as a law instead of a constitutional amendment? Because with a constitutional amendment, we have to follow the Constitution. It really is hard to challenge. And so this is huge. And so I want to make sure that there's not another way to do this. And we're just, I guess that's my question.
Senator?
Chairman Lurcher and Representative Scott, I certainly agree with you. This is a constitution, and it's, to use your word, it is huge. It's very important. As I said before, I think the need and the ability of somebody who's been victimized and had their life altered forever, the ability for them to have a voice in the process, not dictated, but have a voice in the process, is so important that it needs to be enshrined in the Constitution. The terms reasonable and timely, again, gives the court a standard to look at in making their decision whether they move a proceeding or not. But the existing example that we have in place where they just are notified prior, again, you're coming down to something that could simply be prior, which could be right before. So that opportunity to be heard and be effectively heard and have an opportunity to think about it needs to be protected in the Constitution. It doesn't tie the court's hands in determining what's reasonable, but it does emphasize that it needs to be reasonable, and that right needs to be protected in the Constitution.
Representative Smith?
Thank you. Senator, why do we want to substitute this system for our currently functional victims' rights provisions that balance the needs of the victims and defendants? Why do we want this new system?
Mr. Chairman and Representative Smith, this isn't a new system, so to speak. As you mentioned, we've got an existing foundation that deals with notice, opportunity to be heard and be present. This builds on that existing system and provides those additional proceedings that are covered, that give an opportunity to the victim to be heard. Why do we need that? After 22 years, those things are missing and should be there. The victim should have an opportunity or a choice to participate and have their voice heard in those proceedings.
A follow-up.
Smith?
Senator, you mentioned proceedings not presently being covered. Which proceedings are you talking about?
Senator?
Mr. Chairman and Representative Smith, Some of the additional ones that we're talking about are post-conviction relief, parole discharge, change of probation status, commutation, pardon, and post-arrest and post-conviction release.
Follow-up.
Representative Smith.
Say if this bill would pass, does that, and the constitutional amendment passed by the voters, would that mean Idaho is now going to do funding for victim rights program?
Senator.
Mr. Chairman and Representative Smith, again, this is a voluntary system where the victim has the right to choose to be heard. But the right to be notified, the right to be present, the opportunity to be heard are already existing. The notice part does have an obligation and a cost, and they're already doing that. Prosecutors send out notice. It's really more of the notice requirements. They're borne primarily by those initial folks. This provides some additional proceedings where notice would be required, but we're not talking about other services or programs that would have to be provided to victims. This is an opportunity then to participate to the level they choose to. Our responsibility rests in the notice and the opportunity for them to be heard.
Follow-up.
Representative Smith.
The way I understand it, Idaho is currently the only state in the country that does not appropriate funds for victim rights program. All the funding in Idaho comes from federal funding. It comes from the Violence Against Women Act of 1994 and the Victims of Crime Act of 1984. That's where we're getting our money. I have information about how North Dakota passed this amendment and Montana passed this amendment, and you say it won't cost us money. Well, in North Dakota, it's cost up to through 2018. It's cost them $5.2 million. Why won't it impact Idaho?
Lakey.
Mr. Chairman and Representative Smith, I guess first, just for clarification, I didn't say there would be no additional costs. The law that was passed in North Dakota, I can't speak for that. Every state has different laws or different nuances in their constitution. As I mentioned, this comes from an awareness and an observation of some of the national trends, but this is Idaho language that we developed. If we're talking about additional costs, we're talking about the cost, again, to provide additional notice, perhaps additional court time or parole commission time to have to reschedule a hearing if notice wasn't provided. But we're not talking about adding programs. Those aren't the costs that we're talking about. I'm not aware of what victim services the state may provide, but I am aware of the victim services that the local government entities provide. Many of our sheriff's departments have a victim witness coordinator. When I was a prosecutor, we had, I think, one at the local county prosecutor's office. They have, I don't know how many now, 4 or 5. But those are local folks that do that and provide those services. But at this point, it's discretionary. If a state agency wanted to provide victim services, they would come to this body and JFAC and ask for an appropriation to do so.
Thank you.
Representative Giddings.
Thank you, Mr. Chairman and Senator Lakey. I have a question and concern regarding Section 2 on page 2. You have essentially 2 pages of changes to our Idaho Constitution, yet, and a minute ago, you said our current statute kind of already allows a victim to be heard and notified and offered protection. But then the sentence that you have structured to present to the voters just repeats maybe what you said is already accurate, and then it also references equal rights, but nowhere in the 2 pages do I see the verbiage equal rights. So I feel like the summary sentence that you want to provide to the voters is maybe a little bit misleading on what the language actually does. Can you please talk me through how you decided on that sentence in Section 2?
Senator Lakey.
Mr. Chairman and Representative Giddings, I think that provides the summary of items. You know, the additional notification or information that may be provided by the Secretary of State would be developed later. But that tries to provide a broad summary of the provisions here. The equal rights applies in a level sense, in that the rights are equal and that they're provided in the Constitution. However, the amendment itself references the fact that the federal Constitution and the U.S. constitutional rights of the defendant still supersede the victim's rights in this case. So the rights to due process and those kind of things supersede. It's equal in the fact that it's in Idaho Constitution, but the federal protections still apply and would be paramount.
Representative Giddings,
Thank you, that's good.
further questions?
Thank.
Representative Scott, you got one more?
I got 3 more.
Uh-oh.
Fire
We
away.
might have time for the questions, but not for the answers.
I'll talk fast. Thank you, Mr. Chairman. Senator Lakey, you had mentioned that victims do not have a voice in the process. I mean, do they not have a voice in the process already?
Mr. Chairman and Representative Scott, as I mentioned, this is building on a foundation. Victims' experiences vary. This is about providing them an effective voice. And when I use the word effective, I mean the spectrum of the criminal justice proceedings. So they have a constitutional right to have a voice at trial, at sentencing currently. To be effective, you need to make sure they have the right to be heard at the full spectrum of proceedings in the criminal justice system. That's why we added those things. So they have an opportunity, particularly at post-conviction relief or pardon or commutation, where the governor is trying to decide whether to pardon this individual or not. He should be considering the input from the victim. So they have the right to have a voice in certain proceedings at this point. This provides a fuller spectrum or definition of the criminal justice proceedings.
One more
Representative Scott?
follow-up, thank you. Mr. Chairman, Senator Lakey, my next question is line 21. And just because this is going to go into our Constitution if it passes, the statement says the defendant's federal constitutional rights. And shouldn't that be federal Constitution protected rights? Because it's not the Constitution that gives us those rights, but they're protected by the Constitution. So doesn't that need to be changed?
Mr. Chairman and Representative Scott, I appreciate your thought and your process in looking at that. I don't think it needs to be changed. We all recognize that constitutional rights are something that needs to be protected. This just provides that direction to the court. The court's very used to balancing and protecting constitutional rights, and this emphasizes again that these are state rights. The U.S. constitutional rights to due process, speedy trial, those kind of things are not superseded by these. So the court's used to dealing with that.
Okay, one last question,
Senator
please.
Scott.
Thank you, Mr. Chairman. And this might be out of line, so just cut me off if this is not right, Mr.
I
Chairman.
guarantee you I will.
I knew you would. So I have been told that this legislation is being pushed from a billionaire out of California across the country in different states. And I just want to know more about that. Thank you.
Senator Lakey?
Mr. Chairman and Representative Scott, I will certainly say that the Marcy's Law folks have been involved in this process. I don't know the structure of their organization. I do understand it's an individual. The Marcy's Law folks are supported and driven by an individual who had a family member that was killed in California. So it's something that they're passionate about. But what I emphasized was that this is Idaho language. The language, the provisions, the proceedings were all developed with people in Idaho and limited to Idaho proceedings that were appropriate. So we didn't just take whole cloth language from California or other places. Our prosecutors and our courts were involved in applying this to Idaho.
Representative Zito.
Thank you, Mr. Chairman. Senator Lakey. I'm concerned that, and you can answer this question, but let me phrase it. If we do in an amendment to our Constitution what we could do with statute, and then we've seen this where we've enacted what we thought at the time was really good legislation, and then we find out years later that it had unintended consequences that were not good. And now we're seeking to change those and fix that. But the way I understand it, if we do this as an amendment to our Constitution, as a legislature, our hands will be forever tied to fix what might be unintended consequences of this. However, if we do it as a change in statute and law, and then we find out that there were unintended consequences to even sections or lines or words, then as a legislature, we are in a position to change that. Would that be accurate?
Mr. Chairman and Representative Zito, your concept is correct in that this is a constitutional amendment that's ultimately approved by the voters, and that's the only way to change it. But that weighed very heavily on the folks that worked on this. The fact that we are talking about a constitutional amendment, and that has a lot more permanency. Thus, the hours and hours involved to try to craft Idaho language that was appropriate. As has been mentioned, in 1994, Idaho took a leadership role to establish certain rights of victims in the Constitution. In the 22 years of time that's passed, we've learned there are additional aspects in the system that need to be covered. So this provides and adds to that list of proceedings that are covered and protected by the Constitution. It's still, again, in that critical definition of victim, that's a floor. So we have the ability as a legislature to come back and augment that. But you're correct in that it's very important. It's not as easily changed as statute, but this generates a very basic floor list of things that should be protected and covered in the Constitution. Then we have the ability to add on top of that. If we want to include additional proceedings, we can. But this says these proceedings are important to be constitutionally protected.
Thank you.
Representative Giddings.
Thank you, Mr. Chairman and Senator Lakey. One more question for you regarding the fiscal impact. I know we now have a great resource with legislative services where they can provide us some good resources to find out how much a proposal like this would cost. And it sounds like there are other states who are actually figuring out how much it's costing their state, like the good representative, Mrs. Smith, mentioned in North Dakota. And this is a project and a proposal, I think, that you've probably been working on for some time. Can you share with me what efforts you have taken to study the potential Idaho fiscal impact? Because I know that would be very important to the voters and probably something they would want to know when they see this on the ballot.
Certainly. Mr. Chairman and Representative Giddings, that was certainly a topic of discussion, particularly with our representatives from the courts. The challenge you have here, I guess first in trying to compare us with North Dakota or anybody else, their provisions may very well be different. As I said, we developed Idaho language and an application in Idaho. The other challenge that you have is that this is, and rightly so, a system that's discretionary with the victim. And many victims aren't comfortable coming forward and participating directly themselves in the process. They may submit a letter. They may have the prosecutor comment on their behalf. So it's essentially impossible to determine how many more victims may want to come forward or how long they'll talk, so to speak, in a proceeding. So a general awareness that, yes, this could have additional and will have additional impact if we're talking about postage and providing notice to additional victims. That certainly is a real cost. But again, we don't know, depending on crime levels and those kind of things, how much additional notice will be. But we're talking about postage there. The additional time we're talking about, again, depends on the victim's choice to proceed and how long they feel like they need to address the court.
Representative Giddings.
Just one follow-up, Chairman. So Senator Lakey, did you contact Legislative Services for their assistance at all regarding the fiscal impact?
Mr. Chairman and Representative Giddings, Legislative Services was involved in the process of drafting. I think those that would be most familiar with the fiscal impacts are the courts and the prosecutors. And they were involved in the process, but everybody agreed you can't quantify it.
Representative Luker.
Thank you, Mr. Chairman. Senator Lakey, I'd like to touch on a question that Representative Giddings asked about notice, and you indicated that this is a voluntary process, but in terms of the notice, I have a question. Currently, we have an opt-in program where if a victim would like to have notice, they opt in, and that's handled through our VINE program. This, as I read it, would set up an opt-out program. Basically, everybody has to be noticed of every proceeding unless they opt out. Is that correct?
Senator.
Mr. Chairman and Representative Luker, your reference to the VINE program is correct, but the opt-in portion is not exactly correct. The notice that's required to be given at the listed proceedings is a requirement. I mean, the prosecutors now have to provide notice to those listed proceedings. The VINE program, as you mentioned, is a voluntary proceeding that I think is much more efficient. It helps and provides automated notice to victims. I think it would be worthwhile to look at a potential expansion of that as part of this process. So there may be some cost there.
Representative Luker.
Follow-up. Thank you, Mr. Chairman. Senator Lakey, so you indicate the prosecutors have to now give notice. Can you tell us where that requirement comes from and how is it implemented presently, and to which proceedings does it apply presently?
Senator.
Mr. Chairman and Representative Luker, I think the prosecutors could probably give you the best answer as to how it applies and how they utilize it. I think it applies to those proceedings that are currently defined in the Constitution and statute. And these additional proceedings would also be included in that. An expansion of VINE would be a more efficient way to handle some of those notifications. But they can give you the best on-the-ground perspective.
Representative Jordan.
Thank you, Mr. Chairman. Senator Lakey, just a few questions. So going through the language, I have just a few issues. On page 2, I'm looking at lines 4 through 6, and I'm hoping to get some clarity from you. Could you tell me your perspective more so on the meaning of lines 4 through 6 and walk me through that?
You're on page 2, Representative Jordan?
Page 2.
Mr. Chairman and Representative Jordan, again, this is basically an effort to compile those components that were previously listed in different subsections of the constitutional provisions that you can see on page 1 that were lined out. And then we added to those existing proceedings that require notice, the post-conviction relief, the parole discharge, the change in probation status, commutation, pardon, and post-arrest and post-conviction release as proceedings that are important that the victim be notified and have an opportunity to be heard by the decision maker.
A follow-up, Mr. Chairman.
Representative Jordan.
Okay, so now a lot of this is, I think, really going to be frustrating, convoluted language. The other question that I have is in regards to Section D, which is really confusing to me. So being that you're one of the drafters, I'm hoping you can help me with this. Again, page 2, section D, lines 14 through 19. As it says, used in this section, a crime victim shall include any person or entity directly and proximately harmed by the commission or of a felony or a misdemeanor involving physical injury, threatened physical injury, or a sexual offense, or a person or entity against whom such an offense is committed and may be further expanded in law. So what does it mean to be directly versus proximately involved? And can anyone claim to be proximately involved, as well as could that have a negative impact on the victims seeking justice?
Senator.
Mr. Chairman and Representative Jordan, this, and Professor Cassell can talk about kind of the application of that case law, but that's a term that's familiar, particularly in the Federal Victims' Rights Act. But what that does is provide that causal connection. The directly is more of a but-for type of analysis, and then proximately harmed. It has to be both of them, not one or the other. They can't be proximately or directly. It has to be both. And that provides that direct connection to their harm and the criminal act. So the court, again, has case law to look to interpret that. And the definition of victim in our existing code in 1953-06 is perhaps a little bit broader when it talks about an individual who suffers direct or threatened physical, financial, or emotional harm as a result of the commission of a crime or juvenile offense, and includes any charged felony, misdemeanor involving physical injury or threat of physical injury or a sexual offense. So it's fairly similar to what we have now.
Representative Jordan.
Yes, thank you for the follow-up, Mr. Chairman. So Senator Lakey, would this open it up for other outside entities as far as it says here? I understand that you say there is a definition in the code for victim, but being that this would change the Constitution and the general understanding, would this also impact those who would seek justice outside of the victim, meaning that there are now new definitions here as far as an entity or those who are proximately harmed, which could include insurance companies or other outside interests, which means extended relatives?
Senator.
Mr. Chairman and Representative Jordan, again, it has to be both, directly and proximately. The inclusion of the word entity is already included in our state code. I referenced it earlier, but 1953-04, in terms of restitution, it's a victim means a directly injured victim, which means a person or entity. So courts are used to dealing with entities now as victims. What we're talking about is, again, embezzlement or damage to a property by a drunk driver who drives into a company's building. It's not owned by the individual if they're an LLC or a corporation, but that entity has certainly suffered damage or harm that needs to be compensated in the form of restitution. So we're used to, we already deal with entities and persons in our code.
Okay, thank you.
Questions? Thank you, Senator.
Thank you, Mr. Chairman.
Committee, we're due on the floor shortly. Speaker says for us to keep moving forward, but at some point we're going to have to leave. So as you come and testify, would you please do so as succinctly as you can. Paul Cassell.
Mr. Chairman, I'm aware there are some crime victims that have traveled here to be here this morning. I'm wondering if we could, in interest of time, have them move forward next so that they wouldn't be inconvenienced and potentially have to reschedule their trips here.
Who cannot be here at a later time? Would you come forward? State your name for the record.
Lauren Busden. Mr. Chairman, members of the committee, thank you for hearing my testimony today. My name is Lauren Busden. I'm 18 years old and a freshman at the University of Idaho. A little over 4 years ago, in October of 2012, I was 14 and a freshman in high school, and an 18-year-old raped me. I came forward to my parents and the police 2 days after the incident. I went to the local hospital for a rape kit to be performed, but they were not equipped to deal with young victims and had to go to another clinic an hour away from my home, accompanied by a police escort. Soon after, my rapist was arrested and a no-contact order was issued. Upon being arrested, his bond was set at only $3,000, and a few days later, he was bonded out of jail. The presiding judge on the case set strict conditions upon my rapist's release from jail, saying he was to have no unsupervised contact with females under the age of 18, excluding his younger sister. Between the months of October and December, the no-contact order was violated twice with no repercussions. In early December, my rapist requested a hearing to be allowed to leave the state. My family and I were not made aware of this hearing, with my parents acting on my behalf as I was a minor. In late December of 2012, another 14-year-old girl came forward to the police to report that she had been raped by the same man that had raped me, clearly violating his conditions of release. My rapist stayed incarcerated in our local jail throughout the rest of the court proceedings and up until the sentencing hearing, which took place in June of 2013. My rapist had previously pled not guilty to a single count of rape. He was later offered a guilty plea deal and modified the charge to a single count of rape with 2 victims, otherwise known as global resolution. Under this plea deal, my rapist will never have to register as a sex offender. At the sentencing hearing, the courthouse lacked any formal separate waiting areas for court proceedings, so my family and I, along with the other victim, had to sit in a vacant office in order to avoid seeing my rapist's family and friends, who sat in a comfortable waiting area. My rapist was given a 10-year sentence, 3 years to be served, and 7 years indeterminate. The first parole hearing for my rapist occurred in March of 2015. In February, my mom called the Idaho Department of Pardons and Parole, which was at the time without a victim coordinator. I commuted 3 hours to not only attend, but also to testify at my rapist's parole hearing. Upon arriving for the hearing, we were forced to share a waiting area with my rapist family. When it came time to enter into the parole hearing room, my family and I were led into the prisoners' visitors' cafeteria, where we had to sit and wait like second-class citizens. After listening to the commissioner's questions, my family and I were escorted out of the room and back in the visitors' cafeteria to wait a decision. The commissioners of the Pardons and Parole Board denied my rapist's parole, and the next parole hearing was scheduled for September of 2016. In late July of 2016, my mom once again called the Idaho Department of Pardons and Parole to find out more information on the upcoming parole hearing. She found out that a letter was mailed to us, but it had been returned to their office, and no further attempts were made to notify us of the upcoming parole hearing. We only had a few weeks to prepare for my rapist's next hearing, which had been rescheduled to early August without our knowledge. I chose once again to attend and speak at the hearing. My family went to great lengths to avoid being paraded in front of my rapist family or having to share a waiting room. Despite this, we were still forced to sit in a children's playroom while my rapist family sat in the waiting area. At the end of the day, the commissioners once again denied my rapist parole and scheduled the next parole hearing for May of 2017, which I also plan on attending. During this process, I did not feel like I always had an active voice, and furthermore, I felt that my rapist and his family were given better treatment throughout the proceedings. Only because my uncle is an attorney was I made aware of what my victims' rights were and are throughout the entire process. And only because my family is persistent were we made aware of hearings so that my voice could be heard. Throughout the entire process over the last 4 years, I've been treated lesser than my rapist. I'm here today in support of strengthening victims' rights in Idaho's Constitution to ensure others like me do not have to deal with a similar experience in what has to be the most difficult time of their life. Being a victim of rape is the worst thing I have ever experienced. Being left out of opportunities to testify, having no contact orders violated with no repercussions, not having forewarning of upcoming hearings, being paraded in front of my rapist family, and being forced to sit in cafeterias and children's rooms only made it worse. It re-victimizes a person all over again. I ask that you respectfully consider what I've had to say and urge you to enumerate rights for victims in Idaho's Constitution and guarantee the victims of crime will be afforded rights just like accused and convicted criminals. I'm open to questions if there are any.
Representative Scott.
Thank you, Mr. Speaker. I didn't catch your first name.
Mr. Chairman, Representative Scott. Lauren.
Lauren. Thank you, Mr. Speaker. Lauren, my question is on a scale of 1 to 10, the services that the state provided to you as a victim, where would you rate that? On a 1 to 10 scale, what the, everything, the whole ordeal? What were your services?
Mr. Chairman, Representative Scott. Overall, on a scale, the services I received, they really tried to be helpful. So maybe a 7.
Okay.
But, in the end, I was still not included in the process. I didn't get to have a say in whether or not my rapist has to register as a sexual offender. And he doesn't, which is awful. And I had to sit in cafeterias and children's rooms. I didn't get to sit in the waiting area. I wasn't on the same level. I was second class.
Thank you.
Other questions? Representative Luker.
Thank you, Mr. Chairman. One more, if you would. Thank you, Lauren. I know that was not easy for you to come and share. Have you been involved with the VINE program where you asked for notification through that system?
Mr. Chairman, Representative Luker, I believe my mom is signed up for that. I don't believe it's always very consistent, though. I think the notification is few and far between. It's like sometimes you get that message, sometimes you don't.
Okay, thank you.
Other questions? Thank you. Anyone else that cannot return? Let's see. Jake Reynolds.
Good morning.
Be as brief as you can, sir.
I will. Mr. Chairman, and members of the committee, my name is Jake Reynolds. I'm here on behalf of myself and my 2 young kids. In 2012, I went through an unexpected layoff and lost everything I had. I lost my house that I raised my kids in. I inevitably lost joint custody of my kids. I was divorced at the time. I worked as hard as I could over the next 3.5 years to reestablish myself to where I could purchase a home again and provide that stability to my kids and regain that joint custody of my time with them. On January 4th of last year, I finally closed on that house, and I put everything I had into it. I had no additional, everything that I had. I work, I keep to myself, I spend time with my kids or running in the hills with my dog. I'd come back from a run a couple months after I'd closed on my house, went inside for a quick shower and was going to the store to get some food. As I pulled out of my driveway, there had been a storm and collected water. As I pulled out of my driveway and pulled past a neighbor directly next to me, I was coming to a residential intersection. On the left, there was some kids playing in the water. And I waved at them. I knew who they were. And as I looked over to my right, I saw a man that I had never seen before standing on the corner. And when I made eye contact with him, he dropped down in a shooter's stance, pulled out a pistol, and aimed it at my head no further away than you and I are now. I didn't know who this person was. I can't tell you, how fast things go through your head at that moment. I continued through the intersection, maintaining eye contact with that person. And for whatever reason, as I got up past and I stopped trying to decide what to do. I could not let somebody randomly be walking through my neighborhood with a gun, and so I called the police, and I stepped out with my hands up, and I made the call to the police. I told them that I was calling the police. They put the gun back in their waistband and started walking down the street. I watched where they walked into, and they walked into the house on the corner, just next to the neighbor next to me. The police came, they denied everything, searched the house. He was drunk at the time, said he had pulled out a cell phone at 3 o'clock in the morning. I got a call saying they'd found the loaded pistol that he had hidden. And throughout the proceedings of that for the next 3 or 4 months, he denied that he had done anything. Eventually, he did admit to it. I was notified through the process of the upcoming legal side of things, and I did my best to be as involved as possible. Unfortunately, when it came to his sentencing, I was unable to be there. I was told I could give a impact statement or I could be there to explain it myself. I didn't want to even see this person. I lost my sense of security at this house. I can't let my kids go outside and play in the front yard. I don't know him, but I fear for the possibility of something happening again. I can't in good conscience stay there, so within a year's time, I put my house back up for sale with the potential for a pretty big financial loss. Unfortunately, that money can't buy me back that safety of being at that house. Representative Scott, you had made the comment earlier about having a voice. I feel like I had a story. I don't feel like I had a voice. I'm standing before you. Thank God I can stand before you today, and that he didn't twitch and pull the trigger. I'm here to exercise the voice that I don't feel like I was able to have in that process. I'm open to any questions.
Other questions? Representative Scott?
Thank you, Chairman and Jake. So do you realize that what we're passing today is going to have the resources that were spent on you? So obviously government always has trouble. They usually don't always do their job great, and you felt like you didn't have a voice. What we are going to put in the Constitution now is actually going to expand the victims to businesses, business entities. So you're going to be treated the same as Walmart in certain cases. Do you think that's going to help people like you in the future, or do you think that competition is going to hurt people like you?
Chairman, Representative Scott, I can only speak from my personal experience. I feel like I didn't have a voice in the matter.
Right.
As far as an entity itself, if there's a loss of some sort, if I was a business owner, I was actually in a company truck. If he would have pulled the trigger, it would have been a huge loss to the company because, all over the news you would have possibly seen my company truck and the outfit that I represent plastered all over with very negative publicity that could have potentially caused them great financial loss. So do I understand and see the difference?
Yeah.
Of course, I'm not a building, I'm not an
Right.
entity, but there are real life people that affects. And I became close with the owners of the company, and I could only imagine what would happen to them and the 353 people that work for the company if something like that could have been spread around and they could have suffered that financial loss and all the other families affected.
Thank you.
You're welcome.
Representative Luker?
Thank you, Mr. Chairman. Mr. Reynolds, thank you for being here today. I know it's maybe a little nerve-wracking to
It is, I'm
be in-
shaking.
So from what I heard you say, it sounded like you were notified, but there was some other reason you didn't feel like you were heard. And I guess I'd like to know, to what extent were you notified, and then to what extent, for other reasons, do you think you were not heard?
Chairman, Representative Luker, I was notified, and the notification I'm referring to is generally after the fact. I would receive an email basically saying, this is what happened. I wasn't involved in anything prior to. Part of it is I don't know. What I don't know, I can't affect. So having the opportunity to have maybe even had things explained a little bit more if there were additional opportunities to be more involved, I felt like I was very much on the backside. I was planning to sell my house as soon as this thing started going through because I felt completely out of the loop. So what ended up happening is they looked at his background. He had a speeding ticket in the last 20 some odd years. He got some community service, a $500 civil penalty, and was sent home. and he's eligible for withheld judgment once he completes his community service. I feel like there was no concern given for the fact that my children and myself completely lost our sense of safety. In our home, it's our sanctity. That's supposed to be your safe place, and I no longer had that.
Thank you. Just one more.
Representative Luker.
Thank you, Mr. Chairman. Mr. Reynolds. So our current constitutional provision actually requires that you have the right to be heard at all criminal justice proceedings, considering a plea of guilty, sentencing, incarceration, or release of the defendant. So what I'm hearing you saying is that even though we have this in our current constitution, you weren't timely notified of those things?
Chairman, Representative Luker, what my concern is not the notification side. My concern is the fact that, again, I feel like they wanted my story, but they didn't want my voice as far as the ongoing effects of how it was going to impact my life and my children's lives. I just really felt like I was along for the ride. I would get a notification. There wasn't any, specific timeliness to it. Oh, this change, this is going to, happen fairly quickly, and I did everything I could to make myself present for it. I took a position with the county, and we had a pretty strong winter, and so my commitment was we were out taking care of a crazy winter storm, and I had to make that decision between a victim's impact statement or being there to tell the story, which asking the prosecution if there was going to be any difference. The only difference was I would have to stand up there and address this person directly, which I didn't feel comfortable doing that. Other than that, I had no other involvement in what this might do to my future, in my sense of well-being in this home with my children. And other than that, I was notified on the back end of everything, of what happened.
Okay. Further questions? Thank you, sir.
Thank you.
Ashley Burke.
Thank you for having me today, Chairman. I guess my main goal today is to paint a picture of what it is like to be a victim, because my whole life I kind of looked at that whole thing as something very foreign and far away. And what I want to just portray is that there's two different people in a courtroom, two different types of people. One chooses something on why they're there, and one doesn't have any choices of why they're there. And so I hope that when I speak today, you can see me maybe as your son or daughter, your grandson or granddaughter. Hopefully you don't see me as a boy, but, or as yourself, because not one of you probably would choose to be where I was 6 years ago. I'm just going to go back 6 years. In January of 2011, I gave birth to my fifth child. On March 6th of 2011, I celebrated my 7-year anniversary. On March 11th of 2011, I sat on a couch with some detectives telling me that my husband had been shot once in the head and once in the heart because he had had an affair with another man's wife. So a lot of information to find in one day. On March 17th, exactly 6 years ago, 2011, I had a funeral for my husband with my 5 children by my side. And on March 18th, we put his body in the ground. And 10 days later, I, for the first time, went into public by myself to try to find a book that someone had recommended, a grief book. So I was in a bookstore. And I remember my phone ringing, and I picked it up. And the lady on the other end said, "Hey, I don't know if you've heard, but there was a hearing today, and Rob, a traveling judge gave him the option of bail, and his mom posted it, and he is out." And I want you to visualize that for a minute, as me as a person, because I know we hear a lot of stories, we see a lot of movies, and it's always about money, right, in our culture. But really, what this is about is people. And as a person, as a mother of 5 children, as a homeowner in the state of Idaho, I was a lot of things, but at that moment, being a victim of something that I couldn't control again, like 18 days after this tragedy affected my family, that was probably the hardest thing. I remember falling to the ground in that bookstore and sobbing, like, I have no control. Nobody cares how it feels for me. And that's the sad part about being a victim. When you're in that victim mode, you don't realize that there's other people around because you feel so alone. You feel forgotten most of the time. And getting calls like that, you feel worthless and like nobody's ever going to give a damn about how it feels for you to drive home shaking in your car, thinking that maybe he's going to be at your front door or he's already going to be in your house and taking out your family. I had no idea what his intentions were. I didn't know this person. I met his wife a few times because she worked at our law office. So that's the kind of, we want to be informed, but information is critical on when it's received. If I would have been told 4 days before even that was going to be an option, I could have had the opportunity to prepare myself. But also going to the trial a year and a half later, as a victim, I went to hopefully feel like somebody cared. Somebody said, hey, how did that feel for you? Or somebody to say sorry. So I went with a lot of expectations. And what I found was I was trained to be silent. I was trained to not show any emotion because we didn't want to offend the offender. Because so many rights in the state protect him, so he doesn't have to go back through all of his background on everything he's ever done. They focus on that moment for him. And then in that same court, my husband, who had been shot in the heart and the head, we focused on anything that he had ever done, on the reason why he should be killed. So it's a very hard thing to watch as a person, talking about a person that you love that was hurt, and not being taken account that this is real, that my babies have to grow up hearing everything their dad ever did wrong, and that's why he was killed. But the person who did it, we protected him. So that's why I have felt strong about supporting Marcy's Law. Well, not Marcy's Law, written differently for our state. I feel like if I could have stood up at least sometime in that court and just said, can I please just share what real people we're talking about? It wouldn't make a difference. I mean, even being here today, nothing's going to make a difference for me because my story's already gone. But some girl someday, somewhere, I hope that she feels more valued and more appreciated and more recognized. And that's why I'm here, not to make any changes for me. And court didn't even make, we go there for justice, but really what we're looking for is our worth, that hopefully somebody knows that it hurt for us as a victim. So that's what this amendment to the Constitution will do for your babies someday. It'll give them a voice to be able to be at least acknowledged as a person and not feel so alone. I don't know, we live in a culture who, I heard of a guy who robbed a bank and he went to jail, like fixed, 19 years, nothing. And he didn't walk around for 9 months on parole like a man who killed someone. So I think this amendment to this Constitution, what it will really do is focus on people. It's not about money and businesses getting their money back necessarily, but people being heard and seen and valued. Thank you very much.
Other questions?
Open for questions.
Thank you.
Mr. Chairman, I have a question.
Representative Jordan.
I'm sorry, I did not catch your name, ma'am.
It's Ashley Burke.
Ashley Burke. So, Ms. Burke, you mentioned your story and how you feel this needs to change the Constitution to fully justify what has happened to you, and I do thank you for sharing your story this morning. I have similar stories to share that have happened to my own relatives as well, like yours, and very unfortunate in their cause and in fact, how the families had to deal with the aftermath, especially when it came down to prosecution. So you certainly brought to light what many other folks have experienced, which is just our problematic system with prosecution. Do you feel that this would be better addressed in the Idaho Code rather than opening up the Constitution and adding this in?
I think things that are in the Constitution are a lot more likely to be respected by everyone. I'm sure the people following the laws that were trying to protect me felt like they were doing a good job, but I think having stricter guidelines and having it set out in the Constitution will probably be more effective for everyone to be able to apply it to every case.
Further questions? I don't see any. Thank you, ma'am.
Thank you.
There are a number of other people here that have signed up but did not indicate they wanted to testify. Was that your intention? Natalie, is it Natalie March or Mark? Okay, Sarah Buston. Yes, you can. You didn't indicate you wanted to, but please don't come forward.
Thank you for allowing me to speak, Chairman, Commissioners. I'm Sarah Busden. Lauren Busden is my daughter. Because she was a minor at the time, her father and I were automatically victims as well. And I can tell you that we ended up filing a bar complaint. Our prosecutor, great man, respect him immensely, and the system in Blaine County, which I reside, but they failed to notice us of a hearing. And it wasn't out of malice. However, they failed. They didn't give us a chance to speak at this hearing, which was paramount because it was a matter of allowing a rapist to leave our state. And it was just disappointing. And going into this process blind, not knowing what to expect, not having it outlined in detail to us. My brother was a public defender at the time for Canyon County. So he could tell us firsthand the defendant's rights and what would be coming up next and how that would impact us. And he was the one that told me, you have a right to speak at every single hearing. We were in the dark. We didn't know that. And only because of that were we made aware. And he was the one that told us that we had a right to speak at that one particular hearing that they failed to notice us at. So I feel that this would be an asset to the victims here in the state of Idaho, and it would put that pressure on the prosecutors to do their job to the fullest extent that they have available to them and require that notification. And with the Vine network, that is a huge asset. I've utilized it. I have received notifications via text and email, but it doesn't, it's a hit and miss, like my daughter said. It's not every single, upcoming event that deals with parole hearings or his transfers from one facility to another. So thank you.
Other questions? Thank you, ma'am.
Thank you.
Marissa Lovell. Linda, can't read the last name. Burns. Amanda Watson. Sarah Westbrook. Westbrook. Okay. We're really getting up against it. I'm sure they're going to be asking us to get up there in a hurry. Kathy, come on forward.
Good morning, Mr. Chairman, members of the committee. My name is Kathy Grismer. I'm the Policy Director for the ACLU of Idaho. I know that I was signed up to testify, and I know that there's two other individuals also who have signed up whose names haven't been called. But for the ACLU testimony today, I'd like to defer my time to our Legal Director, Richie Epping, who can make some brief comments.
Please state your name for the record.
Thank you, Mr. Chairman. My name is Richard Epping. The last name is Eppink. I'm the legal director of the ACLU of Idaho. I'm going to go a little bit off script, and didn't talk to Kathy about this, but
Recognize that at any minute we can get a demand to go to the floor. So
I understand. I'll try to be brief, but my whole career, I've been an attorney for victims, and the very first 5 years of that career, I was specifically an attorney for victims of rape and sexual assault and domestic violence while I worked at Idaho Legal Aid Services. And so I have worked hand in hand with victims and have encountered some of the very same frustrations that the other victims who have courageously testified here today have talked about. And I do think that there are significant improvements that this state has to make in order to protect those victims in this state. One of them that's outstanding that I am pleased to see is the right in here to confer with the prosecution. That replaces the previous right to communicate with the prosecution. The frustrations that the victims that I represented had often were with the prosecutor, who would not make time to meet and explain what was going on with my clients. And depending on my client's background, I saw again and again how victims got treated differently based on that background that they had. I do think that there are significant problems for victims themselves that are presented by this resolution, including especially the fact that it's going to become a constitutional amendment if passed that will prevent this legislature from making tweaks to prevent to correct what I suspect will be unintended consequences. One of those is the definition of victim and their right to be heard. Before, both in the Constitution that we have, provisions that we have now, and in the statute, that right to be heard was at pleas of guilty, at sentencing, basically after the person who's been presumed innocent has been determined to have committed a crime. That right to be heard will now be expanded throughout the proceeding. That means, and we all know what the criminal defense attorneys are going to do, and I've asked them before standing up here, that means there's going to be a mini hearing where that criminal defense attorney is going to get an opportunity to go after that victim to determine whether or not they are in fact a victim and have a right to be heard before the defendant has been found or pleaded guilty in a case. It's also going to dramatically increase the opportunities that defendants will have to have their cases sent back for second trials, reversed, and otherwise, because that right to be heard will allow victims, give the victims the right to be heard at hearings that have nothing to do with that victim, but have everything to do with constitutional standards, like motions to suppress evidence. That's going to contaminate that record and give criminal defense attorneys an opportunity to argue on appeal that the judge's decision on constitutional standards that cannot include anything that the United States Supreme Court has not set out as part of that standard is that decision was contaminated by that victim's testimony, which may have nothing to do with those constitutional standards. As we heard from some of the victims, prosecutors' offices and victims' witness coordinators already struggle to get notice to folks, and now that notice will have to include notice of post-conviction proceedings, which can occur years later. So the efforts to track down these victims and the delay and potential procedural ramifications for those post-conviction proceedings, as well as all the other proceedings, could actually end up harming victims as well. Ultimately, these provisions bring the victims' rights into a place where they truly overlap with the constitutional protections that defendants are required to have. Now, there's a provision that says, well, nothing's going to supersede those constitutional rights, but that means that you're going to put Idaho judges in the position of having to make very close calls to balance those rights. The more close calls that our judges make, the more likely they're going to make some of those calls wrong, which means the more likely that victims are going to have to come back for second trials, have to be re-victimized by being put through that traumatic process. Again, I know that there's some criminal defense attorneys who will talk more specifically about the ramifications for the constitutional protections that are in the federal Constitution, and so I'll leave that to them. Maybe for me at least, again, speaking probably more personally than anything, but I realize I'm here speaking on behalf of the ACLU, there are the biggest problems here that I see personally are the things that are missing. And there's three of them. One is victims have a right to fairness, respect, dignity, and privacy, but from my own experience, that needs to be clarified in this Constitution, that is regardless of what language somebody speaks, that is regardless of whether someone's a citizen or a non-citizen or an undocumented immigrant, that is regardless of someone's economic or family background. That needs to be in here. There needs to be a guarantee that the perpetrators who are convicted will get the programming they need in prison and in jail and on probation, so that when they come back into our community, they are better people. That's not happening right now, and it's like beating a dog that bit you. We're treating these folks inhumanly in prison, and they're coming out more vicious than when they went in. That doesn't help my clients in the past. That doesn't help the victims today. And then it's already been said, but services, all of my clients at Legal Aid needed health care. They needed mental health care. They needed counseling. They needed housing. Our Victims' Compensation Fund and our private organizations and shelters can only do so much. Those services are just not available in Idaho. And so that could make a huge difference for thousands of victims, rather than muddying the waters with a constitutional amendment, as opposed to at least testing some of these things by statute first. So my apologies to Kathy for maybe going a little bit off the ACLU script, but this is an issue that's really important to me, and I've had an opportunity to see up close what improvements should be made, and I'm very concerned about some of these that will have an adverse and unintended consequence for the people that I have represented in the past.
Are there questions? Representative Scott?
Thank you, Mr. Chairman. I didn't catch your name.
Richard Epping.
Thank you, Mr. Chairman. Richard Epping. My question is, so with these expanded rights going to be putting in our Constitution for victims, what if a victim is not being not getting their needs met, which it sounds like a lot of victims are not getting notifications and that, because this is in the Constitution, would they be able to get a lawyer through the state to fight that during the processes itself?
Mr. Chairman, Representative Scott, I am not aware of any program other than Idaho Legal Aid Services, which receives no state funding, that provides attorneys for victims, and so that is a huge gap. The result will be that those victims who have the means to hire or consult with attorney, what often happens is that if somebody knows an attorney, we heard that today, a relative was an attorney, they get a little bit of guidance, but we don't have those programs. We desperately need those programs.
Follow up.
Representative Scott?
Thank you, Mr. Chairman. Sir, I understand we might not have them, but aren't we going to be required as a state now to provide them?
Mr. Epping?
Mr. Chairman, Representative Scott, I think that could be one interpretation of this language. I doubt that it would be interpreted that way, but I suppose that could be an argument that someone could make, that now the state's obligated to provide those programs.
Okay, thank you.
Representative Crane?
Thank you, Mr. Chairman and Richard. What constitutional rights currently do victims have in the state of Idaho?
Mr. Chairman, Representative Crane, those would be outlined essentially, well, they're already in Article 1, Section 22, and in the resolution, those would be those things that are behind the red line, so to speak.
Representative Crane?
Thank you, Mr. Chairman and Richard. What rights do criminals currently have in Idaho statute?
Mr. Chairman, Representative Crane, those are outlined in other portions of Article 1, and they're also set out in the federal Constitution and the cases that interpret them.
Representative Crane?
Thank you, Mr. Chairman and Richard. So your concern about putting this in the Constitution seems a little bit hollow in the fact that they already have rights. Am I reading that incorrectly?
Mr. Chairman, Representative Crane, if I understand your question, you're saying that my concern about putting these changes in the Constitution is hollow because those rights already exist. If that's the question, then my concern is not about the rights that exist currently. My concern is about the changes that these make in these changes in the resolution would make to the existing constitutional provision, which uses language that has not yet been tested in statute, wouldn't be tested in statute, and that will create consequences, among them judges making far closer calls than they're currently called on to make by the existing provisions. That's going to result in some percentage of error in those calls, which will result in more lengthy proceedings and trials and other proceedings going back to be done again.
Okay, perfect. I appreciate you clarifying that. Mr. Chairman, could I ask another question?
Representative Crane.
Thank you, Mr. Chairman. And Richard, so the argument that we've heard purported today that putting this in the Constitution is what concerns us because we can't change it would probably be a baseless argument, because what we're doing here today is changing the current Constitution. Is that correct?
Mr. Chairman, Representative Crane, the problem is that if you make the change, if the state and its people make the change to the Constitution, the difficulty in changing that, if there are unintended consequences that result in either wild costs beyond what were predicted in this fiscal note or harm to victims, would be, it may be impossible, and it would certainly be difficult. If the legislature made the change in statute, which it could do already, those costs and unintended consequences could be sussed out first to see what, whether this had the effect that was intended, or whether this language, most of which is new, and the fact that the resolution's been through 3 drafts suggests that the language may have, there may be different ways of doing this, then the legislature would be able to sort of drive that car as opposed to turning it out into something that may be unable to get back in the box.
Representative Crane.
Thank you, Mr. Chairman. And Richard, but if our predecessors here got some things wrong in Section 22, Article 1, or as society has evolved, maybe we need to expand those rights. The argument that we can't change those rights is not a valid argument, because that's essentially what this concurrent resolution is seeking to do. Is that correct?
Mr. Chairman, Representative Crane, that is correct. So yes, the state can change its constitution.
Committee, Representative Zito.
Thank you, Mr. Chairman. I just have one quick question. Maybe it will be 2, but try to be brief. So when we amend, and I know you're not a constitutional lawyer, but if we amend the Constitution, typically we add something to it. Is that correct?
Mr. Chairman, Representative Zito, I think it can be both. I think often the Constitution has been amended with additions, but it could also be amended with subtractions.
Okay, so what I'm getting at here is if we add this to the Constitution, it would appear to me that it would be a lot harder at some point to reverse what we've done with this as a constitutional amendment, rather than if we incorporate it into statute, because it's plain to see we need to make some changes. It's plain to see that things are not going well for the victims out there, and that needs to be changed. But would it not be easier to change it in statute and more meaningful rather than to mess with the Constitution and then find out later maybe some verbiage or something wasn't just right, and then to have to go back and change that?
Mr. Chairman, Representative Zito, absolutely, and that was my point. If the legislature is going to experiment, it makes a lot of sense to experiment in statute first.
Any further questions? Representative Armstrong.
Thank you, Mr. Chairman. Mr. Epping, I just have one question. You mentioned that you had 3 major problems with this, and the first one you said that there were a lot of people that undocumented aliens, you had a list of all these people that you were concerned about. I'm wondering, in the language here, which says a crime victim, how does that term, a crime victim, exclude all these people that you're nervous about?
Mr. Chairman, Representative Armstrong, it doesn't. What I'm telling you, just the same as some of the victims have told you, is that what we already have is not happening. And so, for instance, the first provision in the existing constitutional section says that victims shall be treated with fairness, respect, dignity, and privacy. What I'm telling you is just the same as some victims are not getting notified, which they're required to be doing now. Some victims are not getting that fairness, respect, dignity, and privacy. And so I think that the provision should be amended to make sure that that's regardless of their background, regardless of their race, of the language that they speak. That was my point.
I don't see any further questions. We are needed on the floor right now, and so what we're going to do, committee, is we're going to come back here as soon as we adjourn on the House floor and try to finish this up today. So we've gotten leave from the speaker to do that. So what we'll do is we'll recess until and reconvene upon adjournment here. So we'll be at recess.